You're contending that if we look at the accusations, we're going to find that the same conduct was accused once and then dismissed, therefore, under double jeopardy, you should not be or could not be tried again. Is that?
That would be on count 2 and count 3. Now, count 1 was with my van, so I'm not alleging double jeopardy on count 1. Count 3 would be double jeopardy because the state Noah Prost 255B, which originally was obstruction of a police officer, and then after I got bonded out of jail and when the state decided to pursue the case, they changed it from obstruction to failure to show my driver's license, which is the same count as count 3 in this case. Failure to display license. That's why I'm moving for dismissal on counts 2 and 3 for double jeopardy.
All right, let me just, for the record, while we're waiting for the older files, the amended accusation, which was a matter of a little bit of discussion Monday, alleges counts 1, 2, and 3. Count number 1 charges operation of a vehicle without a current license plate. And it says that on the 8th day of April 2014, while operating a motor vehicle which was required to be registered on King Street, did fail to display upon said vehicle a Georgia license plate with current revalidation decal. That's count 1. 8th day of April 2014. Count number 2 alleges operation of a vehicle without current license plate. It alleges that on the 17th of April 2014, you did fail to display upon vehicle a Georgia plate with revalidation on Wright Street. So count 2 is Wright Street, April 17. Count 1 is King Street, April 8. Count number 3, license to be carried and exhibited on demand. This is the 17th of April. Did fail to display his driver's license upon the demand of Jason Bagwell, a law enforcement officer. So those are the 3 allegations that are set forth in the case that's called for trial today.
And if I may submit this to Your Honor, maybe you want to make a copy of it. This is the accusation for 636B, expired tag, which alleges the same set of facts as does count 2 in this case.
Well, it's a different day.
And
a different location from West Cannon Street.
And the different day and different location really means nothing because the Georgia Supreme Court said that as long as the accusation, or I should say the alleged crime, took place, all the allegations took place before the cases were filed, then it would fall under double jeopardy. If I had received, say, an expired tag after the state filed this case, then I couldn't alleged double jeopardy. But all these were before the state filed any charges. The state didn't file a charge on this until April of 2015, if I'm correct. I received all of mine back in 2014. And one in March of 2014, even before they filed any of the other charges. So they would fall under double jeopardy.
Well, in theory, I don't agree with you. I think the question is whether or not they're, the alleged criminal conduct or violation or infraction is one for which you have formally been accused or indicted or presented for prosecution. And it appears to me that unless it's the same conduct on the same date in the same location, that you're dealing with different infractions. Even though it may be the same thing, it would be like going down the street and punching a guy in the nose on Campbell Street, and then across town punching another guy in the nose on West May Street, and the third one on Fifth Avenue.
Well,
It's all the same type of conduct, but it's all done in different locations, and each, the issue of fact for the jury would be whether each of those separate events had all of the elements that constitute the crime with which you're being charged.
and I'll agree with Your Honor on the last part you said. The facts would be the same in each case. That the state would have to prove that I actually needed state plates, okay? However, that's not what the Georgia Supreme Court says in Patterson v. State in 1982 when they talk about double jeopardy. They don't make the claim. In fact, their reasoning is opposite of yours when you're saying that these alleged incidents happened on different dates. The Supreme Court even says as long as no cases were filed by the state, or let me reverse that, as long as I didn't receive any of these after the state filed charges, they would all fall under double jeopardy.
Simply because you're alleging that they could have charged them in the initial case, is that?
That's correct. And that's what the Supreme Court talks about in Patterson v. State.
What's your response to that?
Your Honor, I'm not quite positive that I understand the defendant's argument. It is in our discretion to charge cases when we choose to within a 2-year statute of limitations for a misdemeanor, Your Honor. I believe I filed several of these cases on the same day, even though there were several different offenses that were committed on several different days. I'm not quite sure I understand. I would have to see Patterson versus State to understand what he's speaking about.
Well, you know, I think I know the difference between what's going on here and what Patterson v. State said. There is certainly a requirement that would prevent the state from accumulating several different criminal acts that occurred in a similar or same venue and circumstance, and then holding some back for later prosecution. That would be covered under Patterson v. State. The problem that I see here is that you know, I guess you could say the failure to attach and display a valid, revalidated license plate is a continuing criminal conduct, but it's not, because it's only crime, as I understand it, when he drives it upon the street. And is that
That would
correct?
be the state's position, Your Honor, and I believe, like you said, with Patterson, that deals with if a defendant has appealed or a state is appealing a decision and then they go ahead and prosecute again for the same offense. Your Honor,
That's not what Patterson
understand.
talks about.
Well, it also, I don't know about Patterson specifically, but certainly the state does not have the ability to allege one criminal act out of the same conduct, let it go to appeal, and then prosecute on a separate act with cross or similar elements that occurred during the same event. But that's not what we're dealing with here,
Correct.
in my opinion.
would you like to see these clerks' files?
We're dealing with the same set of facts for each
All right.
accusation.
You go ahead and pull the accusations that have been null-crossed, and let me,
All right, Your Honor. If I may approach with these.
all right, 636B is a one-count accusation